Breaking news, bitter birthday for the FCT minister. Wike's appeal court nullifies the order of the Federal High Court to seize Rivers State federal allocation. Recall that the Federal High Court had earlier ordered the Accountant General of the Federation to withhold the federal allocation of Rivers State for allegedly operating an illegal budget. However, the chairman of the opposition lawmakers, Ikenga Ugochinyere, has made a mockery of Wike and his supporters, describing the ruling of the appellate court as a victory for democracy and the rule of law. Watch the details.
The appeal court judgment today, quashing the Federal High Court order that wanted to seize the River State statutory allocation, is victory for democracy and principles of federalism and constitutional governance, and an end, and a serious end, to the desperate quest by one man to discredit the institution of our judiciary in his quest to seize the public resources of a state. And the opposition lawmakers, commenced the appeal court for redeeming the image of the judiciary and saving it from the desperation of one man who wants to seize the sovereign wealth of the people. Jurisdiction was not there in the first place. So there was even no subject matter to be considered. How can you imagine seizing a statutory revenue of a federating unit using the court like an invitation to constitutional and judicial anarchy? Jurisdiction was not there in the first place, like appeal court have upheld. Jurisdiction is integral, and they know. Supreme Court has held as far back as, in many cases, especially in the case of CBN versus Rahmania Global Resources, that the mere attachment of a federal institution does not confer jurisdiction. You have to look at the subject matter. So because the pro-Wike group was desperate to throw Rivers into anarchy and wanted to cripple the economy of the state, and then they find a Federal High Court available for that, then they went and attached CBN and federal government, so therefore Federal High Court has jurisdiction. This was purely an internal affairs of a state, because we are talking about Appropriation Act. That is law made by the State Assembly. There was nothing that involves CBN interpretation or federal government involvement in it. There's a difference between federal allocation that is moved from the consolidation revenue fund to that of the state. It's a symbol of federating unit. Then when the money gets to the state, when the fund is disbursed from the federation to the federating unit, which is the state, then you talk about appropriation to make budget. And that falls under the powers of the State Assembly. And the State High Court has jurisdiction. But they went to Federal High Court to obtain a judgment. Okay, the cruise of the matter is problem between them and the governor. Is it problem between them and the state? So if a governor is defaulting, and I want Nigerians to pay attention to this, the Constitution has made a elaborate provision to take care of that. There is a State House of Assembly that can impeach. Now, what is the business of the Federal High Court in trying to seize to stop the disbursement of funds from the federation account to the federating unit? Because the federating unit does not have a budget, which is an internal affairs in the state, which is supposed to be the State High Court. People just want us to change our constitutional laws and democracy because of one man quest to seize what does not belong to him.
Thanks for watching. Kindly share your opinion on the comments section. Subscribe to this channel for more stories.